Hello, you are listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira.
Hi, I'm Tammy.
I'm Thomas.
And today we are talking about emergency custody hearings. And the question is...
Child custody, not being in jail.
Okay.
Emergency child custody hearings.
All right. Our audience, I don't think there's any other kind of custody the rest of us think of. But okay, attorney. Emergency child custody hearings. The question is to file or not to file. And we're going to talk about this. This has come up for us a couple times this week. So, we always try to kind of in real time, focus on something that we're kind of up to our eyeballs in that's fresh in our memory.
Yes.
That seems to be, things seem to go in waves. You have multiple people that'll have the same issue in a row. I don't know why that is, but.
Right. Well, it's a common issue for our clients, both our coaching clients and our litigation clients, because it's hard to know whether it's a good idea to file for an emergency hearing or not. Because there's kind of two poles on this, like everything. There's two poles.
Two opposite ends, yeah.
Yeah, and on the one end is your duty as a parent to protect that child. And you have in almost every state, I think in every state, a duty, an absolute duty to protect your child, to provide a safe environment for the child.
Right.
And failure to do so can bring Child Welfare or Child Protective Services a calling. Okay, so you have to take that duty very seriously. Not only that, I mean, as a moral thing, he or she is your kid.
Right.
And he's on the grid. You got to take care of him.
Right. Although it's weird because here's what I find happens. Usually, I'd say the vast majority of people, we are trying to calm them down and tell them that, A, B, C, or D is probably not going to be seen by the court as an emergency, right? When you are talking to people about this.
You're going to let me get to the other pole, aren't you?
Oh.
Yeah, I said there's a pole. See, on the one pole, I'm sorry.
On the one pole, yeah, okay. On the,
I don't mean
back
to interrupt
up.
you.
No, it's okay. I don't want to go out of order
Right.
of things, but so on one pole, you have a duty to protect the child, and then what's the other?
It's a
pole?
powerful duty.
Correct.
You really have to think hard about it. The other side is, though, that if you file an emergency hearing on ex parte that the court finds is not warranted, you can be accused of using it to gain advantage in litigation, or to wrest the child out of the other parent's care, or even to be a vexatious litigant. You don't want to file these willy-nilly. I know that there are some parents that will file 2 or 3 of these, and then a real emergency comes along. And see, they've already spent their shells on
Their capital. It's like the boy that cried wolf.
Right. So you have to really think long and hard. Is this the right thing to do now? And to do that, you have to balance those two things. Now, go ahead. I'm sorry I interrupted.
Well, and this kind of goes into that same thought process, right? Which is that a lot of times when clients call about an emergency hearing, a lot of times I hear Thomas saying, I'm not sure that the court's going to find A, B, C, or D as an emergency.
Right.
And a lot of times it's things that like we know are a concern in the other parent's home, right? We've lived with them. We know if they're doing drugs or alcohol. We know if they're mentally unstable. We know all these things, even if the court doesn't have that depth of information yet.
Right. It's, not your 5-year-old said, "Mom, when are you going to make effing dinner?" Which happens, okay?
Depending on what they hear in the other world or in your world, yes. But, what happens is, usually you're trying to talk people down, but then inevitably, I find this is true also. When we get a call from somebody that really does need an emergency hearing, a lot of times they're the ones that are hesitant, and Thomas is going, no, you got to file this.
Right. Yeah.
You got to file this because you're going to be found to.
That's true. That's a good observation.
Not be protecting your children. So it's kind of, those are the two ends of the pole, right? It's like the person that has been going along and trying not to upset the apple cart and trying to avoid the conflict and all that kind of thing. Sometimes that's the very person that things come to a head and you have to end up filing something. And this is what we're usually trying to tell the people who are wanting to file, multiple times in a row. We're saying, look, you got to wait and let things come to a head on their own. Right. Because my experience is from, watching Thomas do this for years is that if you leave the other parent alone and you focus on your world, if their world is really what the court deems unstable, it will implode on itself.
Right. So maybe we should tell them what we're talking about. So in child custody, normally if you have a divorce case or a paternity case, there's going to be hearings and motions on child custody and visitation. And the court's going to make orders. So normally you'll see orders of joint legal custody, which involves decision making for the child's basic welfare. And then you have the physical custody, or what in California we call the parenting plan.
Right.
And usually the parenting plan is designed to give generous amounts of parenting time to both parents and to have overnight parenting so that those children, when they transfer into the other world, that child is in that world. And that parent is responsible. The parent where the child is living at the time or staying at the time, that parent is the custodial parent, and they have responsibility for the health, safety, and welfare of the child. And the other parent who just dropped off the kid at school can, at that point, go party. Right?
That's what it is. Or as in our case, go work. Right?
Yeah, or go work. Yeah.
That's what we used to do. We'd drop the kids off and be like, whew, 7 days. All right, time to work.
All right, what do we got to do? Break out the to-do list.
Yeah.
All right. So every once in a while, there comes along a situation where the child that one parent forms the opinion that the child is not safe in the other world. So it's a safety issue. It's a big deal. It can be a medical issue, or it can be physical abuse. In some cases, we've had cases of sexual abuse. We had one guy that tried to burn his house down with the kids in it. That's kind of an extreme.
Yeah, you laugh, but you're not laughing because it's funny. You're laughing because of how out there it was.
Yeah, that was an extreme case.
Yeah.
But, in a way, the cases that win at ex partes they all sound a little extreme. It's like, wow, did that really happen? Did he really do that?
Right.
Okay. So the court has this procedure. In California, it's called an ex parte emergency order. In other jurisdictions, it might be something else. But essentially, it's a way to get out and get in front of the court on your case immediately. And so in some cases you give notice, in some cases you don't, but basically you ask the court to set a hearing for the very next day.
Yeah. And let me just chime in a little bit here because my coaching clients are kind of more spread out. Thomas is obviously he's practicing law. And so his clients are all in California on the law side because that's where he's licensed. He's not licensed in any other state. So, and actually all your coaching clients currently are in California. So I have had conversations with people in other states, and I can tell you that it is usually called either an ex parte or an emergency. And, every place has different procedures for this. Even within California, it varies county to county.
That's true.
I know of some states where the parties don't even appear.
Right.
They literally file it ex parte without notice to the other side, and then the judge makes a decision based on the filing.
Based on the pleadings and sets a hearing.
Yeah, and so it can vary a lot state to state. And so where we are, we're in San Diego specifically, and so here where we are, you have to give notice to the other side unless there's a good cause not to.
And sometimes there is.
We've
had a couple of cases, like, for example, we had a case where the child was abducted to another state.
Right, and we didn't give notice.
We did not give notice because we didn't want the abducting parent to hide.
Right. And we had a case where somebody was being financially untruthful over a very long period with the court, and in order to keep our client from moving funds, they filed an ex parte without noticing Thomas, because they were afraid that the funds would disappear.
Right.
Then.
So there's some reason why if you gave notice, it would screw up your case, essentially.
Right. Right. But most of the time, 95, or give or take, you have to give notice. And so here in San Diego, what happens is they actually set a court hearing for the very effects day. Right. The following day or the day after, depending on the timing of when you file. But so we actually go in front of the judge. Sometimes Thomas will get there and the judge will have already looked at it and say, here's my answer. And most of the time the answer's no, if you get it back that quick, but it'll be like the paperwork's waiting for you. Or if the judge has more questions, then, you'll go in and have a very, very short hearing to answer that. So just to make you guys aware, like procedures vary a lot, and even within a state. So you have to check your local rules of how to file these things if you're going to file.
Right. And what the court does is they make a temporary order and then they set a hearing out 21 days. So that the other side gets a chance to file their opposing documents and tell their story.
And 21 days is a California thing.
That's a California thing, but in most states, they have to hold a hearing within a certain number of days.
Right, within a certain period of time. Mm-hmm.
Right. So the typical situation where I file an ex parte might be this. The child comes back with some really severe bruises. So dad takes the child to the pediatrician, and the pediatrician says, this child's being beaten. Okay, this child is being abused. And so to me, that's a dead bang winner ex parte. So the child is in physical danger. Okay. So there are those obvious cases. And then there's ones that kind of split the line, which is a lot of them, actually.
The vast majority of them.
It's like, dad, let's see. The child is saying that dad is smoking some sort of white substance. And you don't have any proof of what it is, but it's a concern. It's a safety concern. Because if the guy's doing crack or crystal meth, or the mom is, that might be, she might not be able to supervise a young child.
Right. Right. But that's sort of a tougher one to prove. And sometimes you have to wait till you have harder evidence. But I want to back up and I want to kind of pull apart the pediatrician thing and the bruises. Okay. I want to kind of look at this from different angles. Okay.
Yeah.
So first of all, a lot of times what happens is somebody sees bruises, they file an ex parte, right? Probably not going to get you there because your and I hate to say this, but this is the fact of the matter. Your interpretation of the bruises isn't viewed in the same way because you have a dog in the fight, right?
Right.
You're one of the parties. So having that outside input, whether it's a therapist, obviously in a bruise, it's a physical thing. So a pediatrician, somebody of that nature, then what happens is you go in, and if the pediatrician says, not sure, doesn't look good, but I can't really say, then, the pediatrician is a mandated reporter. So if they think there's enough there, they will call CPS.
Right.
And so then it's on the pediatrician's judgment, not yours. If the pediatrician doesn't feel like it's warranted to call CPS, then you're probably also not going to get an order out of the court.
Yeah, most likely no.
So if they call CPS though, then
or child welfare in some states.
Child welfare. I'm sorry. Yeah, CPS in California, but child welfare. I know.
I think in a lot of states it is CPS.
Yeah, some places call it
Child Protective Services.
Some places call it DHS, Department of Health Services or Health and Safety or something. And then there's one other acronym I've heard, and I can't remember what that is right now. But anyway, so if you have any of that type of agency involved, then you rely on that agency. Okay, so if that agency, I know this takes time. Like they're not always the fastest if they don't feel like it's life or limb in a lot of ways. And so sometimes you're waiting and you're anxious, and sometimes people will pull the trigger and go in for an ex parte anyway, or an emergency. But if child welfare is not finding it urgent enough to act on like that, again, I think that decreases, your options in court. And because the court's going to want to let that investigation play out. Right. And figure out what that child welfare expert found, if anything.
Right.
And our experience is when it really is warranted and there really is a concern, child welfare will do one of a few things. They'll come back with a safety plan. Right. And they'll say, okay, parent that's doing all these things wrong, you need to change you need to clean up these things, put these things in place, and we're going to come back and check on you in X amount of time. Right. Or you'll kind of get the nudge from them that, like, you need to do something to protect this child. Which kind of tells you, okay, in that case, that's kind of a green light.
In some cases,
to file an ex parte or emergency.
In some cases, they'll take them to the orphanage. They'll take them to we call it Polinsky
here in
San
San Diego, but yeah,
it's a Polinsky Center. But they will basically remove the child from the parents, and you have to be really careful because if and I've had cases like this where I defended a woman once who had allowed her children to witness her being domestically abused by her new husband.
Yeah, and they were a little bit older. They weren't babies.
Yeah, so that's a big thing here in California. I'm not sure about other states, but you really, if you want to have any chance in your custody case, you can't have domestic violence in front of the children.
Yeah.
That's one of those things to leave for the other parent's custodial time, right?
Right.
Have your domestic violence
when the child's not
when
there.
The
Hopefully you're
child's
not having domestic violence either way, or you're getting out if you are.
Well,
but
the problem is the studies show that the conflict itself is the most harmful thing to children.
Right. And in that particular case, the court, this was her second husband that they were witnessing, obviously, though she was in a custody thing with her first husband. But the court actually said to her, this person needs to not be present in the home.
Right.
When your children from your first marriage are present. Right. That was the rule. She couldn't have her kids there if he was present.
And she lost custody at the ex parte.
Yeah.
Because she allowed the children to witness an act of domestic violence that she was the victim of.
Right.
In other words, you have a duty to protect your children. And that's what's important. You have to decide whether I, as a parent, feel that the child is safe transitioning to the other parent.
True. But your feelings can't come from speculation,
right?
Of the white substance, like you said, even though, a lot of times we think, looks like a duck, quacks like a duck, must be a duck. But it's not really always that, unless you have a feather or some cold hard evidence,
right? You need some hard evidence that you're relying on for that belief,
right?
In other words, people say, well, it's hearsay because the child said that dad was hitting me or whatever, and that's hearsay, so it's not admissible. It is admissible. It's not admissible to prove that dad was actually hitting him,
right?
But it is admissible to show that the other parent, the parent that's filing the ex parte,
was worried,
believed that the child was being hit by dad.
Right. Right. So that parent isn't seen as just trying to cause problems.
Right. So really, I guess the standard, if you want to do it, if you're going to file an ex parte for an emergency order for child custody, which, by the way, asks that the custody be transferred to the requesting parent.
Right.
In other words, if you win this motion, you get legal and physical custody.
Temporarily, at least.
Temporarily.
While they investigate.
Until the next hearing.
Right. So what they do is they give you temporary orders while they investigate the situation, whatever format that takes in the court you're in. And then once the investigation is completed, then they'll come back and decide what the permanent order should be moving forward.
But here's what you need to file. You need a subjective belief that the child is not safe in the other world, and you need some objective evidence that makes that a reasonable belief.
Right.
Because a lot of people abuse this system.
A lot. The court sees far more people that abuse it than people that use it correctly.
Right.
So their kind of default assumption is that no. Right. their default assumption on emergency hearings is usually no. So you have to prove that there's really something going on. The more, the vast majority of them are denied in our experience based on our record.
I would say well more than about 70% of them are denied.
Right.
But if you really believe that your child is in danger, you're the parent. You've got to do something.
Yeah.
And you have to take the risk that it'll backfire, because your number one duty is to protect the child.
Right.
But on the other side, we have this situation where people pull the trigger too quickly, or they pull it, or they rely on things that children say the darndest.
Yeah.
And sometimes they say things because they want to make trouble.
Yeah, or they want that parent to be happy, or they want their attention, or they want, there's all kinds of reasons that children do that. And I think the court finds it really hard to rely on children that are especially under 10 years of age.
Right.
Like, it's just because they don't really have those concepts yet.
Right.
But, one of the things that happens too is, like, again, like I said, a lot of times a parent did have concerns about something, like, let's take, maybe drinking. Maybe you had concern about drinking in the very beginning. You tried to verbalize that. That really kind of fell on deaf ears, and this is one reason Thomas and I say every child of a divorced or separated parents should be in therapy. From the time till they're about 3, you really can't, but from 3 to 4 on, your child should be in therapy, even if it's just a once a month touch point with that therapist, so that you have somebody involved that's this objective third party when something goes south.
Objective third party.
Objective. Is that what
you said? Subjective.
Oh, objective.
That's okay.
You said something subjective earlier too, and I thought, did he really mean subjective?
No, it's a subjective belief that's based on a real, like you have
objective.
You have a letter from the pediatrician that says you need to not transition this child.
Yeah. So that's why the therapist is so key. And the very first question when people start saying, I'm having problems with the other parent, I'm having problems with the child, I'm having problems with whatever, our first question is this child in therapy? And if they say no, you say, find a therapist right now. That's like the first place you go.
Right.
But child therapists are very, very difficult to find a good one, I find. But we have a handful. So if you need a reference, you can always shoot us an email. But but they should always be in therapy, especially if you're dealing with problems with the other household that you haven't been able to bring to objective evidence, like Thomas talked about.
That are safety issues or health issues. Or,
right.
Yeah.
And the other thing I was going to say is, like, when the child is, when you have concerns about the child in the other world, where it is, like, let's say alcohol or something of that nature, we've seen cases where in
LSD, crack.
I don't know about all that, but we have seen cases in the first instance. I think alcohol is a common one because it's sort of like, it's not illegal to drink. You can drink. I mean, the thing about heroin and crack is, they're illegal across the board, right?
And marijuana too.
Yeah, but marijuana is not illegal now in California.
Yeah, and in some states, marijuana is in about half.
Yeah, in some states it is, but unfortunately in our state it is not. But anyway.
Unfortunately.
Well, I mean, I think it's highly abused too. I mean, I think
it smells terrible.
It does. I think there's, people that need it, and there's appropriate things for it or whatever, but a vast majority of the time it's not. It's recreational.
Right.
So, anyway, I digress. The point is that if you have concerns, like we've had cases where people had a concern in the first instance, and you're going, you know what, there's really nothing you can do about this. And I always tell people, like, if this is really happening, it will come out eventually. And it never fails. 5 years, 7 years, what if they're really screwed up, 3 years, it usually doesn't take long. And if there's one parent that is really indulging in things that are truly putting the child in danger, that will usually come to somebody's attention.
Right.
Right.
So what about psychological abuse? Like mental abuse.
Why are you asking me that question? How if I ask you?
You want me to
What
answer?
about emotional abuse? What
Yeah.
about verbal abuse? Verbal and emotional abuse are the top two complaints that we hear from people, that
Right.
the other person is verbally and emotionally abusive.
Right. It depends. The answer is it depends. There are forms of mental abuse of children that border on the physical.
Right.
It's like almost like punching them in the gut. Like cussing really loud and telling them they're no good, rotten.
Locking them in a closet.
Lock them in a closet, or other physical things that you can do.
Right.
And I have seen founded cases
Mm-hmm.
from child welfare of emotional abuse of children.
Right.
But I would say that roughly 80% of our clients think that the other parent is abusing their children emotionally. And in no more than 10% of those cases would I even think about filing an ex parte.
Right. Right. Or even really any kind of hearing at all on that issue in a lot of ways.
Yeah.
Because here's what happens for the court. The court says, well, first of all, parental rights are constitutional, right? I know you've heard us say that before. So each parent has a right, and each parent has a right to parent the way they see fit. And so are some of us more calm, gentle parents? Thomas, for instance, yes, we are. Are some of us more hard-nosed and yellers? Yes, I am.
Yelling is the new spanking.
Yeah, I was a yeller. I mean, I was a mom very young, and if I had, I'm in my 50s now. If I was raising a child, I probably wouldn't. I don't do that near as like Thomas's kids are 18 and 19, and I have not yelled at them like that the way I did I do yell at them some, but not like I did my
only when they
own,
deserve it.
my own children. And I know that we're talking about not just yelling. I know we're talking about like being degrading and saying insulting things and
Right.
attacking their. Yeah, you're lazy. You're we don't.
Your mother's a WHORE.
Yeah, and we don't.
Can I say that on the podcast?
I don't know if you can, but you spelled it, so it's okay. But we don't. We don't say. I don't say things like that.
Because,
obviously, that's not what I'm talking about. But
right.
but what I'm saying is, to a certain point, the court kind of goes, well, each parent has their own perspective on what's appropriate. Each parent's entitled to parent the way they see fit. Father or mother may not be father or mother of the year, but do they reach a minimum level of adequacy? Yes. Is the child better off having a father or a mother that occasionally attacks their self-esteem or says things they shouldn't, or better off not having that parent in their life? And that's kind of the dilemma that you're stuck with, which is why verbal and emotional abuse doesn't generally get a lot of traction.
Right. And then there's your exposure to pornography, which I've seen granted.
Right.
There's smoking. A lot of our court orders say no smoking around the child. I mean, in California, it's practically illegal to smoke tobacco. You can smoke all the marijuana you want.
That's weird. It's really screwed up. It really is. But that's not an emergency issue. I don't think that the court would see smoking as an emergency issue.
Well, if you were violating the court order, that you might get some traction out of that. But I don't advise it. I was exposed to tons of secondhand smoke, and I'm 61 years old now, and I have preternaturally good health.
Yeah, and if you drop dead after this podcast, then we're all going to go, you know what? You're never being in the room with my child again while you're smoking.
Yeah, my grandmother was a wonderful woman, chain smoker. Didn't always
lived into her 80s too.
Yeah,
despite the chain smoking.
She did have a stroke, but she lived well into her. Not well. She was 82, I believe. She died.
Yeah.
But
well, my grandmother never smoked, and she was 82.
Right.
So there you go.
Right. So, smoking's bad, and there's a big debate about whether secondhand smoke is bad for children's health. I tend to believe it's hysteria, but a lot of the judges take it seriously.
Right. Right. And so, part of that is judges' opinions don't always match ours, right? We don't always have the same value system. I think it would have been a concern. Fortunately for us, none of us are smokers, but I think it would have been a concern for your younger son when he was little because he had asthma.
He had asthma.
Yeah, I think there's conditions under which it is problematic, right? I mean, if if the uncle comes to visit from out of town one weekend, every 6 months and he smokes around the kid, probably not a big deal. If dad has parties every weekend and the house is smoke filled, okay, the court's probably
Right.
gonna, have a little bit bigger problem.
But,
with that.
beyond the legal considerations, you want to think, well, is this worth blowing up my co-parenting relationship?
Right.
Because filing an ex parte is throwing down the gauntlet.
Yeah, it's pouring gasoline on it.
If I ever got an ex parte request from my ex-wife, I would have had a livid fit. I would have.
Yeah.
That would have been, and it would have been hard for me to trust her after she did that.
Yeah. Yeah, of course there's no reason in our world for the emergency for an emergency concern, but I know sometimes there are. But again, I mean, it's like, I think that it's almost like I need to divide the listening audience in half and say, you people that jump too quick and file too soon and do all those things, stop. And you people that sit back too long and try to avoid the conflict, but you need to protect your kids, you need to move, you need to step up a little more.
Yeah, that's true. The ones that have the best cases, like you said before, are often the ones that are most reluctant to file it.
Yeah, they're the ones that waited, and they waited for the evidence to come.
Right.
And they don't always wait for the evidence to come just because they're waiting for the evidence to come. Sometimes they're waiting because they don't want to deal, or they don't want to have conflict, or they don't want to, whatever. And there is something to be said for that, because like Thomas said earlier, your child witnessing conflict is the absolute worst thing. And so that's kind of what you have to weigh is this a big enough safety concern that I want to create all this conflict with my co-parent and have the child feel that? Because the child's the one going back and forth between the homes and is feeling that tension in each home, And so you have to consider the impact on the child versus the seriousness of the issue. If somebody's driving drunk with the child in the car, obviously we don't care what conflict erupts from it. You got to protect that child's safety.
Yep.
But if things are going on in the other world that you don't like, the conflict may in fact be more harmful than it's worth.
Yeah, I remember having a conversation with a therapist that did a lot of cases that were in court. It was kind of one of the go-to therapists for court, and he said to me, one of the unfortunate things about the system is oftentimes something bad has to happen first,
right,
before the court will act. So the court reacts to a violent incident or domestic violence,
right,
by filing a restraining order, but that violence has already occurred.
Right. Right. And that same therapist told us that when you call child welfare, usually it takes 2 or 3 reports before something is actually done. And I think the reason for that is because the court wants to protect everybody's safety, but they're not there to micromanage your parenting.
Right.
I mean, it's weird to say that because a lot of times that's how we feel. We feel like that is what's happening. I don't have the freedom to do A, B, C, or D because all these orders have been put on me. But all things being equal, the court doesn't want to try to micromanage the situation.
Right.
They want both parents to be good parents. They want to let you both parent, and they will deal if any emergency comes up. And so that's kind of the perspective of it. And then if an emergency comes up and one of the parents has proven that they're not reliable to make good decisions for the child, then that's when you get those micromanaging orders, so to speak.
Right. I guess my final word on this subject would be that this is a question of parental judgment.
Right.
So you have to think, there are so many variables and values that you have to consider. For one thing, you have to consider your relationship with your co-parent. You have to consider the effect that this will have on the child and the child's relationship with the other parent.
Mm-hmm.
You have to, on the other hand, what is the likelihood that this child's really going to get hurt?
Right.
And do I really need, I think that if you make a parental judgment that this child needs to be protected by a court order, then you should file.
Yeah. Yeah. All right. So we hope that gives you some insight and wisdom into this particular issue. It's a pretty common question in our daily work. So if you are listening to the podcast, please don't forget to rate and review us and also subscribe so you're notified as new episodes come out each week. If you're watching us on YouTube, don't forget to hit like on this video and also subscribe so you get notified as new videos are released each week. As always, Thomas and I both run free Facebook groups on custody issues, and so you're welcome to get more information there. To sign up for either one of our groups, obviously, if you're a dad, you go into Thomas's group. If you're a mom, you would go into mine. Facebook.com/groups/custody for moms is mine, and /custody for dads is Thomas's. So we look forward to seeing you next week.
Thank you.
Thank you for listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira. For more information, visit www.divorceuniversityonline.com.